People versus Nicholas Martin.
Good morning, Your Honor. Michael Vincent on behalf of Mr. Martin, who is approaching. Your Honor, today's date time set for a probable cause conference. We need a prelim exam date.
Do you have is discovery complete?
I believe so.
And would the people have their witnesses available the second?
Could I check my, I didn't bring this.
I know, I saw you walking alone. So I knew we were gonna have an issue.
Is that okay? What's good?
You don't know. All right, anyway, preliminary examination. We set in person April 2nd, 2024, 9 a.m. before Judge Perry. Bond continued.
Your Honor, my client wished, I've talked with Ms. Prosecutor, Ms. Hughes. He's an MMA fighter. He wants to go to permission to go to Las Vegas, April 4th.
He's a what?
MMA fighter.
Wow.
I need all the help I can get.
No, it's okay. Alan, be ready.
Anyways, he wants to leave the state from the April 4th to April 15th.
Any objection from the people?
No, thank you.
Where is he going?
Las Vegas. To compete.
Oh, yeah. Sure.
No,
No, I'm just saying, okay, that's your story. Stick to it.
No. He's good. He's won 17 in a row. Hasn't lost any.
You know, me too, when I was young. And that's April.
4th to April 15th.
Okay. Defendant is permitted to travel to Las Vegas, April 4th through April 15th inclusive. All right.
Thank you.
Just for a second. Court calls the case People versus Dolores Strickland. 2 cases.
Judge, Portia, please, the Assistant Public Defender, on behalf of Ms. My right at the podium, Ms. Strickland, please state your name for the record.
Dolores Strickland.
Thank you.
Thank you, Judge. Jane Thompson, PCC matter. I am seeking to adjourn this matter for a few weeks to try to see if we can find a resolution. I know that the people have a motion regarding bond that they want to be heard, Your Honor.
All right.
That's correct, Your Honor. 2 things from, well, the first is that new issues will either be issued today or tomorrow for the case for which she came into custody. I expect that to be 4 felonies.
4 felonies?
Also, I received information that, and forwarded this to the defense, that on 3/6, she left 3 voicemails for the victim, 2 from a different inmate. And in each of the voicemails, she is asking the victim for money. She says, "It's your fault I'm here, so I think you should give my $200. If not, she's gonna go down, like hit the fan. I'm done with this shit. Do it. Get me some money on that commissary now, or else I'm going to effing freak out on you whenever I get that out of here." And we also received information from the victim. This is the DV victim. That she sent her a letter. I got a copy of that letter, which I will need to forward to defense. It's a 5-page handwritten letter. Again, that she sent her a letter. I got a copy of that letter, which I will need to forward to defense. It's a 5-page handwritten letter. Again, that she sent her a letter. I got a copy of that letter, which I will need, asking him for money repeatedly. So I'm going to ask that her be reminded of the no contact order, that her jail call privileges be revoked. I'm going to ask that his number be blocked at the jail as well.
Obviously, Judge, I don't have the letter yet. I was made aware of the phone call last night. We understand the people's request, and Ms. Strickland apologizes for any violations, Your Honor.
You understand, ma'am, you're not to have any contact with the alleged victim in this case.
I do now, Your Honor.
You didn't before?
Well,
Even though the
we've already
magistrate
been
told you?
together, Your Honor, as you've seen on camera. The whole world's seen on camera. And we have been together for 15 years. So He also told them that picked it up, the state that picked it up, that he does not want to see me in jail because of it would not do me no good. It would actually make things worse, Your Honor. So,
Okay, that's fine. You understand you're not to have contact with.
yes, no, I did. Yeah, again.
What date did you want?
We could have at least 2 week, Judge. I'm gonna
2
look
weeks?
into, yes, I'm gonna look into mental health involving Ms. Strickland, determine where we go from there, Judge.
April 4th, 2024, 9 a.m. for probable cause.
Coming April 4th, okay?
Mhm.
All right, I'll come.
Defendant's bond will continue. Defendant's phone privileges are in the jail are hereby revoked.
Again, thank you, Judge.
People versus Dewan Mann.
Good afternoon. Again, Your Honor, Nicole James, attorney on behalf of Mr. Mann. State your name.
Go on, man. All right. What are we doing?
Judge, I'm going to ask that this matter be set for a preliminary examination.
All discovery complete.
I do believe it is, Your Honor.
Will the people have their witnesses available to second?
Judge,
Your Honor.
may I?
Oh, that's right. No, I'm sorry. I was almost, and I was almost going to set that in the middle of Miss James' travel schedule. I forgot to ask before I did it.
Close, Judge. I'm coming out of town next week, but trial before Judge Connolly on the 2nd, and I'll be in another trial on the 9th. Can we do it on the 16th?
Any objection from the people?
Your Honor, if that's the case, I'd like to address bond.
Okay, well, why don't you address bond and let's see what we have to do.
Okay.
Your Honor, this is strangulation. He's out on a PR. There is an Oakland County hold, and he has an incredibly lengthy criminal history, including a 2012 juvenile adjudication for home invasion, a 2013 home invasion, a 2016 home invasion second, which he was given HIDA on. He has a 2013 juvenile adjudication for receiving and concealing, a 2013 juvenile adjudication for religious destruction of the building, 2019 the third, a 2019 receiving and concealing of motor vehicle, 2022 convictions for FTD, 4 2022 convictions for UTA, a 2022 conviction for B&E without intent or without breaking, but with intent, a 2022 conviction for reckless use of a firearm, and a 2022 R&O. We requested 25,000 and he's out on a PR. Again, this is a DV strangulation, and I am extremely concerned for the victim's safety at this point if he is to remain out, and we are to adjourn this exam out beyond 2 weeks.
Any response?
Judge, I would indicate that there is no allegation that Mr. Mann has violated any of the bond conditions. He's been compliant with all the terms. I do understand that he has a lengthy history. However, again, there's no allegation here that he has violated any of the terms. I would ask the court to continue his bond as set. If there was some allegation that he's made contact, I would understand the court considering changing his bond, but at this point in time, there is nothing. And I would also point out that Mr. Mann is employed. He does have 6 children provides for as well.
Your Honor, this was not simply a minor strangulation. My understanding is that he strangled the victim to the point where she lost consciousness. And when she awoke, she regained consciousness while he was tapping on her face, trying to get her attention. And the victim reports that he's threatened to kill her previously and made threats while he was strangling her as well. So at this point, the people did not think the PR was appropriate upon initial granting of it at arraignment. So at this point, it's not a matter of him having complied so far. It's our worry that if this gets adjourned out, there's no contact, the victim's not going to appear because of that contact. I don't think that a PR in this instance is appropriate.
There has not been any contact. This incident occurred back in July of 2023, and there hasn't been any contact since then. The people's worry that there may be contact, I don't think is a legitimate reason for them to request the change in bond, as there hasn't been any. Even though he's been arraigned and he's been out on bond since the arraignment, there hasn't been any contact.
He's arraigned on the 12th,
Correct.
so he's only been out a week.
Correct, Your Honor. It occurred the same day as I filed that other emergency bond motion. Was that same arraignment?
Where's the defendant residing currently?
Your Honor, he lives in Roseville, Michigan.
Did he give the court that address?
Your Honor, that was the address that I was provided with. Is that the address you gave the court?
That's where I live.
Let me see.
He said.
I got it. But are you on a tether?
No, sir.
Where do you work?
I own my own companies.
You tell them what they are.
I don't know.
What?
I own an auto body company, a home remodeling company, and a cleaning service.
Do you, any of those businesses have work in Washtenaw County?
No, sir. All Wayne County and like Macomb. I try to stay from out here. That's
What?
so I try to stay from out here.
Sure that my problem here is that the council approach.
They close at 4:00. If you can make it.
You say this, I gotta pick up my son. But I be well. Yeah,
That's why
I'm
I'm
just gonna take.
Okay.
All right. I guess the question came out record to reflect we had a bench conference. How did you come into custody on this case?
I got into a car accident.
Pardon?
I got into a car accident.
A car incident?
Accident.
A car accident. Somebody had hit me from behind and my car spent out, and then Pittsfield came and they ran my name and I had a warrant that I didn't know about. So they took me.
Okay. But you didn't turn yourself in.
No, I didn't know about it. So I can't turn myself in on something I don't know about. I'm sorry.
Okay. Here's what I'm going to do. It's going to be kind of detailed about this at a conference with counsel at the bench. And I want to make it clear. I don't think that the bond that's set in this case is appropriate. All right. I mean, I honestly think that, and young man, I'll just be clear with you. I think you should have had to have posted a substantial bond given the circumstances in this case. While being mindful of that, I also, however, realized that at least for the last 8 days, nothing has occurred. So, in doing the best that I can to try to balance that, both the interests that the people have and have expressed, as well as what your attorney has indicated on your behalf. I will say this, given the circumstances of this, one thing that is absolutely unacceptable is that there's no tether on you. So I'm going to order, and I'm signing that order right now, that you are to report to the Department of Community Corrections. You're to do that today before you leave these premises to get a GPS tether. For right now, it's going to be location tracking. I'm also going to I want location tracking and an exclusion zone, which is Miss Wanley. I'm going to need you to put that address in because I think it's the same address that I have. It's contained in the file that I don't want him around. I'm going to change your bond to now $25,000. In just weighing everything, and then folks, I'm just doing the best I can. I'm going to give a 10% privilege on that.
Thank you.
So that's going to be $2,500. Given that all of this has come to everybody's attention just as you've gotten here today, that needs to be posted by 9 a.m. tomorrow, the 22nd. Here, do you understand that?
Yes, sir.
I'm going to further indicate to you that if I will be here, so if that bond is not in it by that time, then I'm going to issue a bench warrant for your arrest with no bond, and don't even ask me to change it. Am I understood?
Yes, sir.
I also want to make it very clear, because of how I feel about the bond that is in this case, that if I get any inkling or anything is reported to me that you have had contact, near contact, direct, indirect contact with this victim, I'm just going to revoke your bond. Am I clear?
Yes, sir.
All right. So that's the way I leave it. The other thing that I will do is I'm not going to set it for a preliminary examination at this point. I'm going to adjourn out the probable cause conference. I'm giving defense counsel permission to appear via Zoom. You need to be here.
Okay.
Counsel can appear via Zoom. I will set that next week, the 28th, 2024. I'll set it at 9, but you'll get the time that what block it will be in. Any other questions?
I'm sorry, Judge.
Any other questions on this?
No, Your Honor.
Before he leaves, we will give him a copy of this order. He needs to go right over to Community Corrections and get it put up.
Okay.
Yeah, it's the address on the order. I think that's, I want to check with Ms. Barroso. The International Drive address, is that the address? If you could get that to Ms. Weidling, I think that's it.
Yes, yeah.
That's the address. Yeah. Okay. All right.
Thank you, Your Honor.
Thank you. May be seated. You ready? Court does call the case of the people versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. I think this is people's motion.
Yes, Your Honor. I'm handling this for Ms. Willenbring. There is sensitive information in the police report that includes victims' contact information at home addresses and birthdays. So pursuant to the court rule, Ms. Willenbring would like to redact that information from the police report, but is requesting an order from the court for that effect as well.
All right. First thing, Mr. Jolly, let me just, you are going to continue to represent yourself, sir?
Yes.
All right, I just want to advise you that you are charged with that there are 2 counts on your complaint of criminal sexual conduct in the fourth degree by force or coercion. You understand that, sir?
I understand what the charges are, but never.
Okay. Sir, I have to advise you.
Okay.
You understand that?
I understand.
And that those are high court misdemeanors punishable by up to 2 years incarceration, $5,000 fine plus court costs, mandatory HIV and STD testing.
Okay.
You understand that, sir?
Yeah.
All right. Sir, you wish to continue to represent yourself. The court does have to just advise you and admonish you that I will hold you to the same standards as I would hold somebody that is licensed. You have to abide by all of the court rules, etc. You understand that? All right. And that you won't get any favoritism, and that the court is not in a position and will not assist you if there is something that you don't understand. You are going to be charged with knowing court rules and procedure. You understand that?
But I do.
All right. And I would ask you, or I would also tell you that you do have the right, and if you'd like an opportunity to consult with either a retained lawyer or somebody from the public defender's office, the court would make that occur.
Okay.
You understand that, sir? Okay. Do you have a response to the motion from the people?
I mean, my understanding then is they're going to retract the name, the identification of them, but I'll get the rest of the information. Is it correct?
You would get the rest. My understanding is any identifying information other than name,
Okay.
like address, any phone numbers, anything along those lines would be redacted. Do you have any problem with that, sir?
No, I have no use for that. I guess my
What I would indicate is that I will grant the motion as filed by the people.
Okay.
And there's also a request, I guess, that the motion hearing will be sealed and preserved for review in the result of an appeal.
I mean, yes, because that's what the court rule says. It's a funky court rule.
It is.
Because I haven't said their addresses or phone numbers out loud. It's just that the court rule says that if we're going to redact, that this hearing then becomes sealed.
Yes, it does. It does say that. So, I mean, I'll order it because that's what the court rule says. However, none of that information has been provided on this record. So the record is clear. All right.
Okay, I have a question, Your Honor. Like I said, I have no awareness even of an incident or any conflict occurring at all. I've been obedient I've been good on the tether so far. I talked with Brandon Casey there, my case manager across the street. He thought that I wouldn't have a problem getting off after the first 30 days here.
I'm sorry.
The tether that I have. I mean, I'm a member. I haven't been in trouble. I've been here for years. I don't have something to fight. But
So what are you requesting?
that I get this tether off. It's over. It's only fair. I mean, I've not been in trouble at all in Ann Arbor ever since I've been here. I've been in trouble at all. Not on probation. I have nothing to do with being a trouble with the community at all or anything like that. No witnesses or something. This is just, we grant that, please.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probable cause or anything.
going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes it.